Good morning and good afternoon, depending on where you're joining us from. Welcome to our fifth installment in this special webinar series hosted by GlobalWonks around COVID-19 and its impact on a variety of different industries and sectors. I'm delighted to be joined today by Constantine Partasides, and shortly we'll be hearing from him on what I believe is not just a very relevant topic for this series, but also highlights some of the broader themes around cross-pollination and collaboration between certainly the legal industry and several other adjacent sectors and disciplines. Before we kick off, just a couple of house notes and reminders. We received some good news today at GlobalWonks as we closed our $2 million seed round raise invested in by Userbase Inc., which we're delighted about. This is great news for our experts, but as our clients too, for whom we're constantly looking to evolve and enhance our products. And really that brings me on to another point that I think it's worth mentioning, given that we've had a real influx of lawyers attending today's call and webinar. And that is what the relevance of our business and products are for the legal industry. And essentially what we do is we build real-time expert network and expert insights products for professional services and clients across the board. The chief one being Network Pulse, which is a real-time Q&A tool, kind of like a LinkedIn meets Quora. And it's a product relevant to a whole host of professional services clients, and we believe also to law firms as well. And I think that both our product and today's talk speaks to essentially the value of bringing together the worlds of law and certainly the two worlds that we cover, which is business and policy. You know, where we aim purely to help organizations overcome organizational and business silos that can help them enhance operationally, but also in terms of their business success. And I think some of the salient points from today's talk will certainly nod towards a greater integration of certainly what happens in the legal field and some of the economic underpinnings and assumptions in business and policy. And so if you'd like to hear and understand more about our products, please do get in touch with matt.putnam@globalwonks.com. So let's get started. As I mentioned, delighted to have Constantine Partasides here with us today giving a talk. As mentioned in the promotion of the webinar, Constantine will be covering questions about classical solutions offered by the law to corporates during large-scale crises such as pandemics, as well as speaking to alternative and evolving frameworks around dispute resolutions, which may otherwise lead to unsatisfactory economic outcomes. You know, this has particularly been highlighted during COVID-19, but I think part of our discussion today should address how we can get ahead of some of these changes and shifts that Constantine will be hypothesizing and prescribing. Constantine Partasides is a Queen's Counsel and has appeared as a counsel on some of the largest commercial arbitration cases of the last decade, many of which relate to the energy sector. He has recently led teams that obtained a monetary award for clients against the Kurdistan regional government for $1.98 billion, a final award for a consortium of clients against the Nigerian National Petroleum Company in excess of $2 billion, and a final award for ConocoPhillips against PDVSA in excess of $2 billion. He has also advised and represented a variety of investors and states in relation to disputes under relevant bilateral and multilateral investment treaties, and was counsel of record on high-profile ICSID successes for the Republic of Kenya in World Duty Free versus Republic of Kenya, and the Republic of Lithuania in Parkrings versus Republic of Lithuania. He is leading a team for Elliott Associates in an arbitration under the Korea-US Free Trade Agreement against the Republic of Korea, and also has been named as the top 20 individuals in the world of arbitration in the who's who of commercial arbitration since 2011. I think most notably for many of you joining us today, he's the co-author of the 4th, 5th, and 6th editions of the leading textbook in international arbitration, Redfern and Hunter on international arbitration. He's a solicitor advocate and was appointed Queen's Counsel in 2014. Constantine completed his education at King's College London and Cambridge University. As always, for those attending our talk today, please use the Q&A function at the bottom of your screens throughout the talk to submit as many questions as you'd like. Our goal is to get through as many of them as possible at the end of the talk. So with that said, Constantine, the floor is yours.
Thank you, Bilal, and hello, ladies and gentlemen. As Bilal has mentioned, I am an international arbitration lawyer, which means that I spend my professional life advising and advocating for clients in their cross-border disputes. Those are disputes that are referred for resolution not to national courts, but to international arbitration. And I also sit myself as arbitrator deciding such disputes as well. And from my vantage point, looking out across the world of international dispute resolution, I am already seeing the first wave of legal disputes that are arising from the disruption that the global pandemic and the governmental measures introduced to address it have caused. These disputes are arising because many parties now find themselves bound to contracts that have become difficult or impossible or even pointless to perform. And other parties on the other side of those same contracts are finding themselves, even if they can perform, now party to contracts where their counterparty is confronted by some impossibility or other reason why performance has become more difficult, with knock-on consequences for those other parties as well. That wave of disputes has already begun, and we anticipate that it will grow, and in the language of the pandemic that we have all regrettably become familiar with, that it will be followed by a second wave and perhaps further waves of those disputes. And as we contemplate that, we should ask ourselves the following question. Will the way in which the world of law and dispute resolution deals with such claim waves have its own impact on how quickly and how well the global economy recovers from the crisis that it presently finds itself in? And I think the answer to that is undoubtedly yes. So the question that I and other lawyers have been asking ourselves is, how can the world of international dispute resolution best deal with those coming claim waves so that we can make a contribution to the economic recovery that we should all be working for as the health crisis, hopefully, itself subsides? Now, the immediate answer to that question is by providing quality, predictable, and efficient legal resolution to the disputes that are coming. But in offering that, what I might call stock answer, let us ask ourselves further whether traditional legal solutions to disputes will alone be enough to help the international economy find the best way out of a global crisis that we all now recognize is unprecedented in its scale. Those traditional legal solutions are typically binary in their nature. They typically deliver winners and losers, and losing the day after the economic ravages of the coronavirus will often mean collapse, and every collapse will lead to many more collapses in our interdependent world. Let's consider, by way of example, the insurance industry. We already know that an avalanche of claims will be coming for business interruption. If many of them are entirely successful, we may not have an insurance industry left standing. If, on the other hand, many of them entirely fail, the devastating effect throughout multiple levels of the international economy could be even more far-reaching. And so binary outcomes, such as these, may amplify the economic damage, making overall recovery all the more difficult. Now, economists have already started thinking along these lines. Those writing in April for the IMF blog have identified 3 pivotal policy objectives in order to pave the way to recovery. First, guaranteeing the functioning of essential sectors Second, providing enough resources for people hit by the crisis. And third, preventing excessive economic disruption. And with these economic policy objectives in mind, they have advocated for economic measures aimed at protecting liquidity and solvency as widely as possible. And so the question that I pose is, shouldn't we lawyers be thinking along the same lines too? Well, some already are, with a group from the British Institute of International and Comparative Law, led by two of the UK's most distinguished former judges, calling recently for breathing space in the form of temporary relief for those unable to fulfill their obligations under viable contracts. And I and a group of lawyers at my law firm, 3 Crowns, have been thinking along the same lines and have been considering how to take such ideas a little further. And I propose to introduce some of those ideas to you all today. But let's first lay the groundwork by looking at some of the classical legal solutions that exist to disruptions and changes in circumstances and what their limitations might be. Those classical legal solutions include concepts such as force majeure, frustration, hardship, and the various notions that are derived in some legal systems from the duty of good faith. Now, in the time available, I'll introduce just one of them, the concept of force majeure, which is simply defined as unforeseen circumstances that prevent someone from fulfilling its contract in a way that is unattributable to that party, i.e. making performance impossible through no fault of the defaulting party, and thereby constituting a valid defense to a claim for non-performance. And having heard that definition, you won't be surprised to hear that force majeure claims are already spiraling. Parties are already arguing that the COVID-19 pandemic is an unforeseeable event beyond their control that renders performance either completely or partially impossible. And by the way, the same force majeure arguments arose a century ago in the wake of the Spanish flu epidemic of 1918 to 1920, and some of those century-old claims make particularly interesting reading today. But the volume of such claims that we are likely to see today will surely dwarf anything previously seen in the history of litigation and arbitration. And so we must ask ourselves, what kind of solutions will the concept of force majeure, relied on now exponentially, give us today? Well, the concept is largely a creature of contract. It's largely a creature of contractual definition, and those contractual definitions will vary from contract to contract. But what we can expect is that the outcome of applying those contractual definitions will tend towards the binary. A party will either achieve full or partial exoneration from its performance, or it will not. And aside from the question of formal impossibility of performance, that outcome may not take into account the economic implications of performance or non-performance for either of the parties to the contract or indeed third parties. Let me give you an example. Let us imagine a contract between a supplier and a purchaser. And let us imagine that the supplier is delayed in its supply, not because it was physically impossible to supply to the contractual schedule, but because it decided to implement working practices that conformed to national or WHO health guidelines on social distancing in the workplace, which in turn led to lower productivity and delayed its ability to supply. Now, as performance was not strictly impossible, depending on the terms of the force majeure provision in that particular contract, it might not qualify as a force majeure, even though the supplier's conduct was reasonable and indeed responsible. And yet a strict application of a force majeure provision may leave no room for such considerations, and nor will it often take into account the sudden onerousness of performance. In this case, the case of my example, requiring a contracting party to choose between failing to meet a contractual deadline by following health guidelines, or alternatively, requiring that contract party to disregard sensible health guidelines so as to meet its contractual deadline. So, the classical solutions and their limits. How does one transcend these largely binary legal outcomes that may not allow adjudicators sufficiently to take into account all of the particular circumstances of the present crisis? Let us imagine a world in which legal solutions were not only designed to give us a winner and a loser, but were also designed to minimize disruption by salvaging viable contracts so as to avoid the collapse of contractual relationships and the parties to them. Might more flexible legal answers beyond classical contract law be found? Let us look, by way of analogy, to aspects of bankruptcy law, which contemplate various arrangements that are designed to foster business survival in the interests of all of a business's creditors. By way of example, under the English Insolvency Act, a company's directors can, in certain circumstances, propose a voluntary scheme of arrangement to its creditors that can involve restructuring of a company's debts, including the reduction of financial obligations such as interest, and a rollover or moratorium of its obligations to a later date. Now, creditors accept such arrangements in their own self-interest in order to avoid debtor collapse and so as to maximize their own long-term recovery. Perhaps such methods for fostering the survival of contracts and the parties to them might now have broader application and appeal as businesses around the world seek to avoid collapse in the age of coronavirus. So how might we introduce these more flexible means for preserving contracts and protecting the parties to them? Well, let me suggest in at least two different ways. Substantively, they could form part of a new national or international law on recovery, a new so-called recovery code, a code that exceptionally moderates rights and obligations under existing contracts that are impacted by this emergency so as to ameliorate the most extreme consequences of performance. Now, lawyers alone are not best placed to come up with such a code. A multidisciplinary team of lawyers and economists, for example, needs to advise on what the terms of such a code might look like together. That's one possible substantive approach to introducing greater flexibility. Let me turn next to a procedural approach. Such concepts could also be introduced at the dispute resolution stage by introducing new claims mechanisms, including mass claims mechanisms, by which parties agree to refer their disputes to an alternative dispute resolution mechanism, an alternative mechanism in which the parties agree to empower their adjudicator with a mandate to arrive at a dispute solution that takes into account not only the strict impossibility or otherwise of performance, but also the particular onerousness of performance in the circumstances of the coronavirus pandemic, as well as the imperative of arriving at outcomes that reduce economic disruption and preserve viable contracts. Let me end my introduction to this hour-long session with some brief takeaways. A wave of claims is already arriving. If those claims are dealt with slowly, inconsistently, and with no regard to reaching outcomes that minimize economic disruption, our recession will be deeper and longer, and our recovery shallower and slower. Classical contract solutions do exist, and they offer us many solutions. But in these exceptional times, maybe we now should be looking a little further so that legal solutions can go further in assisting in a post-coronavirus recovery. I think, Bilal, that ends my introductory remarks, and I invite any questions you might have.